standpoint of law. Advocates are not meant to be one-eyed monsters to look at only one side of a case. They do acquire a binocular vision in most cases. Legal planning is similar to the care we take to avoid collapse of buildings by sticking to properly planned structures by civil engineers and rendering him powerless and his clients vulnerable. A civil engineer is confident of his ability to design buildings which can withstand even earthquakes if he has so designed them, whereas lawyers in India at present have to fight unpredictability of judgments, compelling them to behave like gamblers on the psychology of judges. It was all right for Lord Krishna to sermonize Arjuna to do his duty and leave the result to him. By applying this analogy and ignoring predictability of judgments, lawyers have placed themselves in a position of the clergy. 529. Downgrading two sides to solve the mystery and deliver justice. Hello my viewers, in this next part of my video I am going to cover the topic predictability and legal planning. In the previous video, the reality of reality, it was stated that rule of law will pave the way for predictability of judgments. The main benefit of predictability of judgments is that citizens can legally plan their transactions to avoid litigation, and if litigation is thrust upon them, ensure success in court cases if competent and honest advocates are hired. They can also avoid criminal prosecutions by suitably molding their transactions, and if they are maliciously prosecuted, they can not only be confident of getting acquittals, but also take legal action against those who harass them by suing for damages for malicious prosecution. If the citizens really commit crimes, they can choose to go in for plea bargain and get maximum concessions in punishments while satisfying the aggrieved complainants for securing convictions. The police also can get professional satisfaction for sincerely investigating and prosecuting the culprits by spurning bribes and withstanding pressures from various quarters. Legal planning is similar to the care we take to avoid collapse of buildings by sticking to properly planned structures by civil engineers and architects. We do not mind paying a decent fee to them just for their drawing plans, as they are supposed to keep the principles of engineering in view for their drawings. If lawyers are hired to draft contracts, the clients can hope to enforce them through law courts, as the contracts are designed by keeping mandatory legal principles in mind. In a decision reported in 2009 AIR Supreme Court Weekly 5121, Global Energy Limited versus Central Electricity Regulatory Commission, the Honorable Supreme Court has held that law has to provide basic level of legal security by ensuring that law is knowable, dependable, and shielded from excessive manipulation. For instance, if a client wants to gift his property to his son but wants to impose a condition permanently restraining sale of property, the lawyer can advise him that such a condition cannot be enforced as it violates Section 10 of the Transfer of Property Act. If the seller of immovable property wants to avoid a contract of sale on the ground that the stipulated time for paying the sale consideration is over, his lawyer can tell him that time is not the essence of a contract to sell immovable property as per the settled law, and unless the limitation period of 3 years expires, the contract is very much alive. If a creditor wants to proceed against the personal properties of a director of or a shareholder of a limited company, his legal expert can advise him that the judge cannot sell the personal assets, as the liability of the debtor company is limited to the assets of the company, which is distinct legal entity created by a legal fiction, as the Companies Act mandates only limited liability, notwithstanding the gut feelings of any judge who itches to impose the liability on the other personal assets of the director. The difference is a civil engineer has no option but to comply with the law of nature, that is physics, like gravity, strength of materials, etc. In India, at present, a lawyer has to gamble on the psychology of judges, rendering him powerless and his clients vulnerable. A civil engineer is confident of his ability to design buildings which can withstand even earthquakes if he has so designed them, whereas lawyers in India at present have to fight unpredictability of judgments, compelling them to behave like gamblers on the psychology of judges. It was all right for Lord Krishna to sermonize Arjuna to do his duty and leave the result to him. By applying this analogy and ignoring predictability of judgments, lawyers have placed themselves in a position of the clergy, downgrading the consumer of judicial service to the level of humble devotees. It is for the lawyers in this country to unite and fight the tyranny of unpredictability. Let us not forget that it was the legal profession that took the lead to fight the tyranny of the British rule in India. The true translation of the word judge, that includes juries when they existed here, ought to be nirneta, or the one who decides. Judge, nirneta. As Indians, being predominantly Hindus, follow idol worship, this was subconsciously made to work on our minds in calling judges Nyayamurtis. And naturally, some judges assume that they are the embodiments of justice. Why should they care? Binding precedents or the law? Generations of lawyers here have been cautioned by their seniors in this Guru Sishya Parampara. Remember, it's all right to lose 10 cases, but not one judge, implying that it will be too costly for lawyers to antagonize judges even if they behave like emperors. And Rule 1 of the Bar Council rules that mandates that advocates have a right and duty to complain against judges who commit serious wrongs is not even taught in law colleges, mind you, senior lawyers, chambers, or in judicial academies. No wonder lawyers in India have become priests. Idol worship in temples is all right, but in a court of law, it is disastrous. At the cost of reputation, I state that a citizen should be enabled to have a fairly accurate idea about the result of litigation, at least in a majority of cases, and he should not be at the mercy of a judge or a bureaucrat or any person in authority to get the relief by betting on their psychology. As the Honorable Supreme Court held, court proceedings are not like buying a lottery ticket. This was laid down in Rakesh Kumar Goel versus UP State Industrial Development Corporation Limited. It is reported in 2010 Supreme Court Weekly 4050. Judicial discretion does not cover whim, fancy, or caprice of the judge. This was laid down in Supreme Appeals Reporter 2001, page 623. Departmental inquiry was ordered against a judicial officer who passed blatantly illegal order. This is Sai Baba versus Karim Khan, 2003-3, Andhra Legal Decisions 403. Judges should not get swayed by personal notions or by ideas of eminent jurists. Binding judgments should be the Bible. This was laid down in Oma alias Om Prakash versus State of Tamil Nadu, 2013, Supreme Court Weekly 529. Two sides of a coin analogy is misleading. Both lawyers and judges in this country are surprised when they are told that judgments should be predictable. How can lawyers predict judgments? After all, there are two sides of a coin and each lawyer presents his case, that is to say, his side of the coin, and leaves it to the judge, who is assumed to be an embodiment of justice, that is, Nyayamurti, to solve the mystery and deliver justice. If lawyers can predict judgments, judges will have no role to play, will they? Lawyer's job is to project jigsaw puzzles at judges, and it is for the judges to solve them. This is the sum and substance of the impression of both lawyers and judges in this country. Lawyers are treated as problem creators rather than problem solvers. It is the job of lawyers to throw jigsaw puzzles at the judges, and it is for the judges to solve them. This two sides of a coin analogy suffers from a serious defect. In the case of a coin, both the sides must be intact and valid for it to be in circulation. In a court judgment, in most cases, the judge cannot say that the arguments of both the sides are valid. One must be valid, that is to say, a good case or a diamond, and the other must be untenable, that is to say, a cheap stone. The judge's role is to merely certify which side possesses a diamond and which side clings to a cheap stone from a standpoint of law. Advocates are not meant to be one-eyed monsters to look at only one side of a case. They do acquire a binocular vision in most cases. The first step is to be taken by an advocate is the issuance of a notice to the opposite side narrating the case of his client as per his instructions and calling upon the opposite side to do anything mandated by law or refrain from doing something prohibited by law. The lawyer on the opposite side will have the benefit of knowing the case of both the parties, one as contained in the lawyer's notice and the other as stated to him by his client. If the contents of the original notice are legally tenable, either wholly or in part, the opposite lawyer should advise his client to comply with the notice so as to avoid costly litigation. His client might be an ordinary businessman or a powerful bureaucrat, politician holding high political office. When Nani Palkewala was briefed by his client, Srimati Indira Gandhi, to file an appeal before the Honorable Supreme Court and secure a stay of the judgment of the Allahabad High Court, setting aside her election as a member of the Lok Sabha, the eminent jurist accepted the brief and succeeded in getting a stay from the Honorable Supreme Court. But shortly thereafter, when his client, namely the Prime Minister of India, imposed emergency, Sri Palkhiwala returned the brief to his client, suggesting her to engage some other advocate as he did not approve her action in imposing an emergency. I am stating this only to show that a lawyer cannot be compelled by his client to act against what the advocate thinks to be right. I am not commenting on the merits of the decision to impose internal emergency, as that is beyond the scope of my lecture. I therefore request those in my audience who felt that the emergency was justified not to give me a political color. The next weapon an advocate enjoys is provided by Order 11 CPC, calling for selection of documents which are proved to be in possession of the opposite party. This will enable him to know the other side of the coin. Order 12 Civil Procedure Code also gives a weapon to the lawyer to call upon the opposite side to admit the validity of certain documents or the existence of some facts. This will also enable him to know what the case of the other side is. These two procedures will help the lawyers of both the sides to avoid going in for trial, which is time consuming and expensive, both to the litigant in terms of the fee and to the state in terms of its expenditure to provide adequate judicial machinery to its citizens to conduct the luxury of a trial. That too by a jury. Here we don't have juries. It is high time we have them. The last weapon given to a lawyer to discover the truth in his function as an inquisitorial judge is cross-examination, where skillful cross-examination will go a long way in exposing the falsehood of the opposite side. It is to be remembered that trial in a court of law should be at least should be a last resort and not a routine exercise. And if lawyers appearing for both the litigating parties are efficient and honest, in most cases, needless trials can be avoided. Therefore, lawyers are meant to be unofficial judges. In most of the matches on the playground, the players themselves know which side has won. Only in rare cases, the services of referees are required to formally certify the victors. Similarly, officially appointed judges at the expense of taxpayer ought to be required only in a minuscule percentage of cases, as the greater part of adjudicatory function ought to be discharged by informal judges called legal experts. Therefore, lawyers are meant to be problem solvers and not problem creators. After the trial is concluded and before the arguments are advanced, both the lawyers know their respective cases, and if both are honest and efficient, they can arrive at a consensus, obviating the need for official judge to give his formal judgment. Now I am going to show you. Here is the sketch of the ideal judiciary which I contemplate. Now, this is the foundation, as you can see here, and the above is the superstructure. Predictability of judgments forms the basis for the superstructure. Predictability will result in instant conversion of all diligent lawyers as judges of the private sector, who play inquisitorial, that is to say, investigative role. Judges and juries paid by the state will step in only to act as referees in adversarial courts when private sector judges, that is, advocates, disagree. This is alternative dispute resolution, ADR. When judges also disagree, majority prevails. Adding to the judge strength and improving their caliber will definitely help. Integrity of lawyers and judges is an additional requirement which depends upon the general prosperity of the profession and salaries of judges. Here I may add, ensuring universal basic income, which is the modern concept, will help many lawyers to support themselves when there is need, so that they don't stoop to below the normal acceptable levels of conduct. In criminal cases, as questions of fact predominate, reintroduction of jury trials and strengthening the investigation prosecution machinery will ensure predictability, paving the way for plea bargaining, resulting in a major portion of criminal cases being settled by this procedure within a month or two after the filing of the charge sheets. In the US, more than 90% of criminal cases are settled this way. Once the public realize that there is no delay in disposal of cases, the total volume of work for lawyers would increase, resulting in a win-all situation to the legal profession, raising its general prosperity and ensuring the rule of law to the society. Then coming to civil matters, here in the inquisitorial role of lawyers, facts gathered by advocates by voluntary disclosure. About 20% of cases are settled at the stage of consultation and exchange of notices in lawyers' chambers. So usually it takes about 1 month and both the advocates get paid. It's a win-win situation for the advocates. There are no losers here. Then, if this stage is crossed and if the matter is not settled, then the matter goes to court. At that stage, facts facts are accessed by advocates by employing the judge's coercive power. For example, 70% of the cases get settled by lawyers by consent after discovery and inspection under Order 11 CPC. The Order 12 also is relevant. Both the advocates get paid proportionately. It's a win-win situation for advocates, and cases are disposed of in 3 months. This could happen in about 70% cases. And once this stage is crossed and the matters are not yet settled, then the cases they go to the stage of trial. Here what happens? About 8% of the cases are settled by judges after trial and arguments. Advocates, of course, they get paid, and this process may take about 6 to 8 months. And in 2% of the cases, appeals are also filed, and they are also settled by judges. And advocates get a 200% fee, one at the stage of trial and one at the stage of the appeal. Now, first of all, why trial and appeal are required? Under ideal conditions, when the law or facts are vague, or litigants are adamant, or due to lawyers or judges' error of judgment or dishonesty. So only in such cases the role of the official judges, adversarial judges, is required. Otherwise, lawyers themselves can settle the matters. And second appeals and further appeals, they become very rare, declogging the higher judiciary. So this is how the judiciary is actually expected to work. When the disease is one thing at present, the disease is lack of predictability, first thing. The second one is, of course, lack of honesty, which is due to poverty of the advocates, and universal basic income is the solution. So here, when the disease is one thing, what we are doing, our diagnosis is faulty, and the treatment is naturally further faulty. Lok adalats, how will they work? They will not work. I have already explained this in some other segment of my video. Then ADRs, they are all totally wrong concepts. First, enhance predictability of judgments. That's what I am saying. Quick delivery of justice. If there are 10 doctors in a town, it might take half an hour for the average patient to get himself examined and treated by a doctor. If the number of doctors is increased to 20, the time taken for each patient gets reduced by half, and so on progressively. As the number of doctors increases, the waiting period for the patients decreases. But in the case of advocates, even if the number of advocates increases to several lakhs, the citizen doesn't get justice more quickly in India, because in our mindset, it is only the officially appointed judge who can deliver justice. And due to resource constraints and apathy, the number of official judges can never be increased indefinitely. Even in the United States, the system of plea bargaining was introduced to enable legal system to cope with the workload, which would have simply collapsed like a pack of cards due to the ever-increasing workload, which could not have been handled by the judges alone, with advocates irresponsibly and merrily contesting every criminal case as it is being done in India at present. The Supreme Court of the United States upheld plea bargaining procedure when it was challenged as unconstitutional. Therefore, when there is predictability of judgments, every advocate becomes an unofficial judge who is paid by the consumer and not the taxpayer. This is important. In the form of consultation fee, to get the same judgment in a few hours or days, a service which might take years for an official judge to give. Ensuring predictability of judgments is the key requirement. Advocate also gets professional satisfaction that he could deliver the goods to his client. Without predictability, legal advice is futile, whether it is the Attorney General of India who advises the Union government, the Advocate General of a state who advises the state government, legal advisor of a bank who advises his client as to the clear title of the prospective borrower to execute a valid mortgage to the bank, or an ordinary legal advisor who advises the public on the various legal aspects before purchasing properties. There is an implied assumption that the judgments of courts are predictable to a large extent, if not to an extent of 100%. If lawyers are only priests to appear before man-made gods called judges, it is futile to ask them to to show how godly judges would react to a given situation. In a temple, since we cannot directly communicate with God, we tend to hire priests to do so in a language that God understands. Such languages are Sanskrit for Hindus, Persian for Muslims, and English, etc. for Christians. Since our godly judges are easily available in their residential quarters, it will be better to advise the clients to approach the man-made gods to know whether they would grant a boon, or by ensuring victory, whether they would grant a boon or hand over a curse by ensuring defeat in litigation. And wait, we all use some offerings to God called Naivedyam to please him to give us boons. Why not we do the same thing to our judges? After all, it is their gut feeling that ultimately decides the cases, and not the so-called mandatory provisions of law or binding precedents. It is only for avoiding such absurdities that the higher judiciary has evolved so many rules to control the discretion of judges. If judges overlook them, disciplinary action shall follow. Those rules of conduct are extracted below. Illustrations. A. Order 17, Rule 2 Civil Procedure Code mandates day-to-day postings of trial unless there are special reasons to be recorded in writing to deviate from this rule. Order 41, Rule 11A mandates that appeals shall be disposed of within 60 days from the date of presentation of the appeal. C. When statute enjoins a judge to draw a presumption, whether rebuttable or irrebuttable, the judge shall not omit to draw such presumption while assessing the evidence of the judgment. This is based on the ratio reported in 2002-2 Andhra Legal Decisions 843. Ailuri Usha Swami versus Vijay Pre-Stressed Products Private Limited. Judges who ignore these mandates of law shall be suitably punished. When the civil court decide constitutional validity of enactments, please don't be shocked, as the answer is yes, as laid down by a bench of 8 judges. This may be a sort of a digression from the main subject of predictability. However, in view of the importance of this subject, I may be permitted to speak about it for a few minutes. The civil court also can decide constitutional validity of enactments. This legal position came into existence when the Honorable Supreme Court held in L. Chandar Kumar versus Union of India, AIR 1997, Supreme Court 1125. The earliest decision and probably the only decision was in AIR 1971, Mysore 355, State of Mysore versus B. Basavalingappa. Under Order 27A Civil Procedure Code, it is contemplated that such a suit can be filed. The court is expected to give notice to the Attorney General if a central enactment is challenged, and the Advocate General if the state enactment is involved. The court cannot strike down the enactment so that it will apply in rem, as the higher judiciary can do. But the civil court can only declare that a particular enactment or a part thereof is unconstitutional, and the benefit of the declaration only goes to the parties to the suit. Third parties are not bound by such judgment. A judge is not an investigator but an umpire. This was explained in my first video, Speedy Justice Part 1. To avoid the tedium of repetition, I request the audience to watch it to know the details. By way of an addition, I am quoting another decision of 5-judge bench of the Supreme Court that followed this dictum. It is fundamental that the procedure before a tribunal like that in a court of law should be adversary and not inquisitorial. The tribunal should have both sides of the case presented to it and should decide between them without itself having to conduct an inquiry of its own motion, enter into the controversy, and call evidence for or against either party. If it allows itself to become involved in the investigation and argument, parties will quickly lose confidence in its impartiality, however fair-minded it may be in fact. This was laid down in Krishnaswamy versus Union of India, AIR 1993, Supreme Court 1407. 5 judges, mind you, a constitution bench. According to F.S. Nariman, the basic structure theory of the Indian Constitution first originated in the mind of Advocate Nani Palkiwala. It later merely got the stamp of approval by the apex court, and the liberties of the entire subcontinent were saved from the clutches of the executive and the legislature. In other words, the basic structure theory of the Indian Constitution was compressed into crystallized form, just as artificial diamond is created by compressing carbon by the judges based on the thought process of Advocate Nani Palkiwala in Keshavananda Bharati's case. That was in 1973. Sri Nariman also is of the opinion that a judge is like a referee in a football match. He may run with the players to get a proper look at the ball. He cannot participate in the game by kicking the ball himself or advise the players as to how they should play. Justice Sri Krishna also expressed a similar opinion, about which I have already spoken in my earlier video. Can delivering justice be reduced to just a game to be played by lawyers? By now, many of those who have watched my videos would have thought that delivering justice is too noble and important function to be reduced to just a sport or a game to be played merrily by lawyers. Judges also might have felt a sense of indignation that they are compared to just referees in a match. What is this? We thought we are Nyayamurtis. Justice emanates from us. This man calls us only referees in a match. Now let me clarify their doubts. In my video, The Reality of Reality, I have explained how truth is relative to the observer. Let us take the instance of legal recognition of private property by a court of law. God or nature, as the case may be, never ordained that a certain piece of land shall be the private property of a certain individual. We are all reminded that we enter the world empty-handed and we depart. We don't carry any baggage with us. I have already explained in that video how a communist would justifiably argue that all land belongs to the entire human society and there shall be no private property at all. A saint would sermonize that all land belongs to God alone, and a street rowdy would threaten that everything in the street belongs to him. With this background, all economic activities like sale and purchase, lending and recovery, and exchange of goods and services, marriages and divorces, innumerable such activities that are regulated by law, these laws are all man-made laws. They are not divine sanctions. So just as we have so many rules in tennis, football, basketball, cricket, these laws are also made for our convenience. Those who act according to those laws become victorious, and those who fail to play properly become the vanquished. Looking from this perspective, the judge, while protecting possession by an injunction, effecting partition of properties, declaring title to properties, granting specific performance of contracts, or a host of other rights, only decides who has won and who has lost the game that was played by the parties to the litigation prior to their entering the law courts. This is important. When arguing a case, the advocates only give their assessment to the judge as to which of the parties played the game more efficiently and correctly before they knocked at the doors of the court. Ideally speaking, cases should be won or lost on account of their inherent strength or weakness. A competent lawyer should be enabled to judge in advance whether the client has brought a diamond or a cheap stone. In case it is a diamond, a lawyer is expected to cut it properly by pruning the bulky facts to the barest minimum, which is called a brief. His skills of cross-examination and arguments are like uncovering and polishing a pre-existing diamond to bring out its glitter by removing the mud and grime that had hidden the diamond like facts. Even the most competent lawyer cannot convert a cheap stone into a diamond. For instance, the ablest lawyers, the most expensive lawyers in this country, they cannot persuade a court to declare the Taj Mahal as a private property of an ambitious client. But an inefficient lawyer might mistake a diamond for a cheap stone or damage an actual diamond due to his lack of skill in cutting it properly. That is why the litigant public do not mind hiring good lawyers by paying a hefty fee. Even while deciding criminal cases, if a person kills another in exercise of his right of private defense, he is declared to be not guilty by applying the penal law. The same law is applied to decide who is an aggressor and who is a mere defender. In the absence of these man-made laws, a saint would decide that nothing, in the absence of these man-made laws, a saint would decide that nothing happens unless God so intends and injuncts. If temple property is stolen, there is no need to set the law into motion by a police complaint, as God would recover his own property. Similarly, private property has no meaning for a saint. So there can be nothing like theft. There is no question of punishing a person for theft or robbery or dacoity. If a person has killed another, it is because it was so ordained by God. Since you cannot punish God for murder, you should not punish the helpless murderer who only carried out the orders of God. It is only when we apply man-made laws that the judge or the jury can decide who is to be punished and who is to be let off. When a person seeks legal advice before entering into any commercial or economic transaction, the lawyer acts like a guide and a coach. This is important. The lawyer acts like a guide and a coach to enable the citizen to play the game correctly so that he gets solidified and crystallized rights enforceable through the law courts.